is visible. This is a second session on our conveyancing paper. Alafu one thing that I have come to greatly appreciate is the fact that so far tumepitia many statutes of the law. We have interpreted section by section, and the same is forming a pattern. The same sahi imeanza kuform a pattern behind our minds, in that if you see a certain question, ushaisikia hiyo concept ama you know the tricky parts that students usually go wrong. So, and that is the basis of maybe many students hawajaipitia hizi statutes. That's why unaona vitu zinaanza kukua sasa normal on our part. So like for the undertakings, kuna najua tu in as much as ni kama tumebrush over, but the little that you have scoped imesaidia kuliko ungejipata you have the question before you but you don't know what to do. So question 4, I was to jump straight into question 4. So your client Bond is buying a property from Flavian whose details are as follows. The title number, Thika Block 18, property situated within Thika Town. Title is leasehold with commercial user. Then sale price is 10 million. Flavian had purchased the property for 5 million from Grace. Then after buying the property from Grace, Flavian was involved in a lawsuit over the same property and spent 500,000 defending the case successfully. After the case ended, Flavian spent another 1 million building a perimeter wall, and the sale price of 10 million is inclusive of all developments. Then Flavian had spent a further 500,000 in legal fees and sales commission. So even before we answer this question, to show you that we will be asked a question on capital gains tax calculations. So A, discuss the principles and procedure undertaken in stamp duty valuation, and in this case indicate what factors will affect stamp duty valuation. B, between the parties to this transaction, who bears the legal liability for tax in respect of stamp duty and capital gains tax? C, will the liability for stamp duty change if Bond and Flavian were cousins and Flavian gave Bond the property for free? D, assist the parties compute capital gains tax payable, if any. 3 marks. Stamp duty valuation, what are the principles, procedure, and valuation factors here? 4 marks. Stamp duty is assessed on the property's true open market value at the date of transfer. If KRA doubts the declared consideration, it triggers government valuation and can demand additional duty and register a restriction. Governing rules, Section 10A of the Stamp Duty Act. The collector of stamp duties may refer a conveyance or transfer of immovable property to the chief government valuer or valuer appointed by the county government to determine true open market value and demand any additional stamp duty, and may register caveats or restrictions where additional duty is found to be due. Procedure, what usually happens in practice? You go into the iTax stamp duty assessment. So the iTax stamp duty assessment is initiated normally by the purchaser's advocate using the transfer details, the title number, consideration, and the parties. So marking point, purchaser's advocate is the one who initiates this process. Then the collector may refer for valuation under Section 10A of the Stamp Duty Act. Okay. Then CGV issues a stamp duty value, open market value, as a transfer date. So you'll be given a stamp duty value. So in practice, this process is known as franking, and it is done person to the at the Ministry of Land hapo side za inaitwaje community. So you are given a value because I may notice that this property is having this market value price. So that is what happens. Alafu unapata the valuer was duly appointed to you pursuant to the new portal at the SASA platform, where if you lodge any transfer application, you'll be able to see the progress of your transfer. If it is conversion of a title, you will have submitted the title, then the portal will say that we have duly received your title, then wait for allocation of a valuer. So once you are allocated a valuer, then the valuer will issue you with an invoice so that you pay, because the valuer indeed went to the land physically and confirmed the market value of the same. So duty is paid on the assessed value. If CGV values, capital gains, CGV value, hapo siko sure, I can't remember exactly what I meant by CGV. If the value is above declared consideration, additional duty is demanded and payable within the statutory period. Section 10 A2 of the Stamp Duty Act. Restrictions may be placed on the title. So if it happens that you have underdeclared your considerations in any way, then we can say that they have the power to register a restriction on the title. So what question are we answering? Stamp duty valuation principles and procedure and valuation factors. So it is an open-ended question. That's why I've tried to incorporate all these elements in between. So factors that will affect valuation in this case. Location is Thika town. It's an urban commercial market. Then the tenure and interest, leasehold. We need to look at the remaining term, ground rent, covenants, any restrictions, and user, commercial user, typically higher than residential, depending on zoning and demand. Another idea is that, sorry, excuse, in a few. So in this part, naweza sema for the I have analyzed many conveyancing papers, and I have seen a question arising, a change of user, where a person is being told to convert a certain property from semi-agricultural land to private or commercial land. So there is a procedure, and if you are keen, in my YouTube channel nimefanya one session nimeweka all possible conveyancing procedures, and inside the channel kwa hiyo exact video utapata I have also discussed on the procedure that you will follow for change of user, because it is a common question. Iko na strict timelines, iko na a certain inaitwa liaison committee. If you ever have a dispute arising from the county executive member that you duly submitted your application to, and they made a decision and maybe they refused your change of user application within a number of 30 days or 60 days, I'll confirm, 60 days, then you will have the right kwanza to go before the liaison committee before going to court. So unapata examiners wamenote students usually avoid the procedural aspects that have been laid down in the acts to address their grievances. So they target students mwenye atasema a remedy that this person can go to ni directly to court. Marking scheme inasema failure to go to the liaison committee or exhaust the provided remedies. So that was a trick I saw ilitumika in a certain paper. Haya. So now factors that will affect valuation, stamp duty valuation. We have said the location, we have said the tenure will also affect, and the user. So because we have said that commercial user is typically higher than residential, then we have also said that plot or building attributes, what is the size, what is the access, services, neighborhood, comparables, okay? Then developments included, inclusive of all developments, improvements, e.g. perimeter wall, will be reflected in the market value even if not itemized, okay? Then declared consideration is also a factor that will affect valuation. So 10 million will be questioned if below market price. Valuation then drives the tax base. Okay, so those are the factors that we have seen will affect valuation. Who bears the legal liability to pay stamp duty and capital gains tax? 1 mark. Stamp duty liability is borne by the transferee or purchaser, bond in this case, while capital gains tax liability is borne by the transferor or the vendor, in this case being Flavian. Okay, so those hiyo tu ni 1 mark yenye una scoop mbio mbio. Authority is that capital gains tax is a tax on gains arising on transfer of property by the person disposing the same. This is provided for under Income Tax Act Section 34 in the 9th Schedule, a link capital gains tax charged under the capital gains tax framework in the 9th Schedule, where the vendor is the disposer. Stamp duty purchaser liability is standard practice. The relevant or charging or collection sections were not returned clearly by my search engine tool. Okay. If they are cousins and it is gifted for free, does stamp duty change? Okay, so you need another trick that the examiner was testing. Yes, stamp duty is still payable. A gift is charged as if it were a sale, using market value as the duty base, not zero consideration. Okay, what are the governing rules? Gift inter vivos are chargeable with stamp duty as conveyance on sale, substituting value for consideration. So, relationship or by the name cousin does not by itself remove stamp duty. Duty is assessed on market value. Section 52 of the Stamp Duty Act. Okay. D. The student was required to compute capital gains tax. 3 marks. On the given facts, taxable gain, because we've been told that the capital gains tax is a tax charged on the gains on a certain property. 3 million. So capital gains tax is 5% of that. So it will be 150 million because you are assuming that no exceptions will apply because the question is silent. Capital gains tax applies to gains on transfer of property under the Income Tax Act capital gains tax regime, 9th Schedule, rate applied via the Act's rate provisions. Okay. So basically, the examiner had interpreted all these figures that are directly projected before you. We have the consideration being 10 million, inclusive of developments. We have allowable cost base. In this, we say purchase price paid to Grace was 5 million. Capital improvement, we saw a perimeter wall, 1 million, improvement enhancing the value of the property. Incidental cost of transfer, any legal fees or sales commissions arising, we saw the same to be 500,000. Then litigation defense cost, because we have been told there was a case, successfully defending ownership, you used 500,000. So this is treated as part of acquisition or defense of title cost in many practical capital gains tax computations. So what is the formula? So the formula is gain, okay, total cost base. You calculate kwanza total cost base provided. So we have 5 million, we have 1 million, we have 500,000, so inakuja 7 million. Then what is the gain? The transfer value was 10 million. So you less the total cost base, you get 3 million. Then you take the 5% of the gain from this property. Okay. So what you need to take note of is that confirm whether the property qualifies for any capital gains tax exemption. Expect stamp duty to be assessed on the higher of declared consideration versus CGV, open market value, bill timing for valuation and potential additional duty demand under Section 10A Stamp Duty Act. Okay, so basically we can say that when sijaweka hiyo formula, I don't know where kuweka. Kuna formula that interpret now the information that was given by the examiner in this question. So if you look at the question, we can identify the 10 million being the sale price. You can see that Flavian had purchased the property for 5 million. Hiyo tumeona, that's why tuliweka pale chini. After buying the property, there is a lawsuit, then aka-incur 1 million building a perimeter wall. This is an additional value to the property. Then Flavian had spent a further 500,000. So basically una add hizi zote, una less from the 10 million, then you do the percentage, unapata 3 marks. Somebody told me that lazima tutapata question on taxation one way or another, either stamp duty or capital gains tax. They are frequent. Question 5. Your client Maria is purchasing a commercial block housing 20 tenants. The block houses shops, restaurants, and offices. At the point of due diligence, you establish the following. 10 of the tenants have leases for 6 years which have been executed at different times and each registered against the title. 2. 5 of the tenants have similar 6-year leases duly executed and witnessed by the advocate handling the leases for the landlord was taken ill over a year ago and the leases were neither duly stamped nor registered. Okay? 3. The last 5 tenants had leases that expired at different times over the last 1 year, and although the owner or landlord gave instructions to his advocate to prepare new leases, the same was never done, and the 5 tenants have continued to pay the rent they were paying at expiry of the leases. A. Discuss the status of the first set of leases in one above and how they affect your client's impending purchase. How will you deal with them in the sale agreement? Before we answer, kwanza acha tuelewe hiyo one inamaanisha nini in simple term. You have identified 10 of the tenants have leases for 6 years which have been executed at different times and each registered against the title. Now you are to discuss the status of the first set of leases in one above and how they affect your client's impending purchase. How will you deal with them in the sale agreement? B. Discuss the legal effects of the lack of stamping and lack of registration of the second set of leases. Second set of leases inamaanisha aje? 5 of the tenants have similar 6-year leases duly executed and witnessed by the advocate handling the leases for the landlord was taken in a year ago. Okay, and the leases were neither duly stamped nor registered. 3. The last 5 tenants had leases that expired at different times over the last 1 year, and although the owner or landlord gave instructions to his advocate to prepare new leases, the same was never done, and the 5 tenants have continued to pay the rent they were paying at expiry of the leases. Question C. How will you advise your client purchaser to deal with this second set of unstamped and unregistered leases? What are the likely safeguards you could build into the sale agreement to protect your client purchaser in respect of the effects you have discussed in B above? D. What is the legal effect of the lack of leases in the third set of tenancies, Roman 3 above? How will you advise your client purchaser to deal with this set of leases, and what safeguards could you build into the sale agreement to protect your client purchaser in respect of the effects of the lack of leases? 3 marks. Tuanze na 1. Status of the first set of leases registered 6-year leases and effect on the purchase, how to deal with them in the sale agreement. They are valid registrable instruments binding on the land and will bind Maria as the purchaser. She buys the block subject to those registered leases and the tenant's quiet enjoyment. Governing rules. A disposition, including a lease, does not operate to create or to transfer or effect an interest until it is registered. Section 43(2) of the Land Registration Act. Priority of registered interest follows presentation or registration order. Section 36(5) of the Land Registration Act. Practical drafting sale agreement expressly state that the sale is subject to existing registered leases listed in a schedule, tenant names, rent, provide the details. Include warranties that 1. The disclosed registered leases are the only registered occupational interest. No arrears, seller to assign, hand over rent roll, deposits and tenants files on completion. That is the effect that those leases that have been registered will have to the sale agreement. So in short, hapa nakwambia you will expressly include the clause subject to existing registered leases, because the disposition that has been registered will also follow the interest that is to be acquired by Maria. Okay. B, legal effects of stamping and lack of registration of the second set, executed 6-year leases and stamped plus unregistered. Unstamped plus unregistered 6-year leases won't create a registrable legal lease interest binding on third parties. They may still operate as contracts between the original landlord and the tenant's occupation remains a real risk to a purchaser. Unregistered instruments don't affect interest in land but may still operate as a contract. Remember, legal effects. What is the legal effect? Unregistered instrument does not affect interest in land but may still operate as a contract. Section 36(1)(2) of the Land Registration Act. Then, no instrument chargeable with stamp duty may be registered or acted upon unless duly stamped. Unstamped instruments are generally inadmissible until duty or penalty is dealt with. Section 19 of the Stamp Duty Act. We have also seen a decision. Unstamped or unregistered lease cannot pass a registrable interest beyond a contract inter partes. Faisal Sharif Mohammed versus Kirima Bus Services Limited 2012. The court found that the plaintiff failed to establish a prima facie case for the grant of mandatory or temporary injunctions. The lease relied upon by the plaintiff was neither stamped nor registered, rendering it incapable of passing any interest in the suit premises beyond a contract inter partes. The plaintiff also failed to demonstrate payment of the full rent due, as the evidence showed substantial arrears. The court held that the circumstances did not meet the threshold for granting a mandatory injunction, which is reserved for clear cases with special circumstances. Consequently, the plaintiff's application for injunction was dismissed. Unstamped lease is inadmissible as evidence until stamp duty compliance. Landmark International Properties Limited versus Anne Wangari Munene 2022. Ratio decidendi. The court found that the lease agreement presented by the intended interested party was inadmissible as evidence at this stage due to non-payment of stamp duty in accordance with Section 19 of the Stamp Duty Act. However, despite the inadmissibility of the lease, both the plaintiff and the defendant acknowledged the applicant's occupation of the suit premises. The court determined that, given the applicant's occupation and the defendant's effort to remove it, the applicant was a necessary party for the effectual and complete adjudication of the dispute. Therefore, the applicant was admitted as an interested party. The court declined to grant injunctive relief to the applicant as it had not pleaded any claim in the suit and the lease agreement it relied upon was inadmissible. The application for joinder was allowed, but the request for a restraining order was denied. So it teaches you one thing. If an examiner placed before you a fact, a statement of fact that this client is clearly merely paying rent but is sitting on a lease that is beyond 5 years, because the law says any lease above 5 years or 5 years should be registered for it to take effect. Above 2 years, above 2 years, not 2 years, it should be registered for it to take effect. So alafu anakukujia that wewe unakimbia kusema let me go and take an injunction against this property. So we can see decisions inasema that is merely a contract between two people, but the document that you are coming before you are showing us before this court is an invalid document because you have not paid for stamp duty. No, you have not registered for the same. So let us just add you as a party, but no relief for this instance. So inatupea pia an open overview of looking at various applications before court. Question C. How Maria should deal with the second set safeguards its sale agreement. Treat them as occupational liabilities that can disrupt vacant possession or rent restructuring. Either regularize them pre-completion or price, or escrow the risk and require clean contractual handover. So maybe for us to understand C, why I brought up C, is because C was saying, how will you advise your client purchaser to deal with the second set of unstamped and unregistered leases? Okay, and what are the likely safeguards you could use in your sale agreement to protect the purchaser? So this C is giving the answers to that. So safeguards to build is that condition precedents or preferred is that the seller to stamp and register the 5 leases or procure surrenders or new registrable leases before completion at seller's cost with proof. So you first start with regularization, then 2, full disclosure or warranty or indemnity. Seller warrants there are no other leases or side letters and indemnifies purchaser for all losses or claims arising from those 5 tenants asserting longer terms or renewal rights and compensation. So we saw that pale kwa indemnity and warranty clause when we were drafting above. Retention or escrow. Hold a retention from purchase price, a quantified amount, for a defined period to cover litigation or settlement costs if tenants challenge purchaser's management. Then 4, tenant confirmations. Each tenant confirms the term they are under, rent deposit, no options, acknowledges sale, and undertakes to atone to purchaser. So those are additional steps because the question wanted 3 marks. So step number 1, regularization, have an indemnity clause, then have an escrow arrangement or peer tenants confirmation themselves and undertaking from them. D, third set involved expired leases. The tenants were still staying on the same parcel and they were still paying the same rent. What is the legal effect? What is the advice and the safeguards that you are to take? These are no longer fixed-term leases. Continued occupation with rent payment typically results into a periodic tenancy or tenancy by holding over. So Maria still buys subject to the occupation and must manage termination or renegotiation risk. Governing rule. A periodic lease is a short-term lease and is not a registrable interest. It may be oral or written. Section 58 1B 3 of the Land Act. A tenancy can be inferred from conduct, occupation and rent repayment even without a formal registered lease. Jamii Bora Bank Limited versus James Gitau 2018. The court found that although the formal lease was inadmissible for lack of stamping and registration, the parties' correspondence and conduct established a binding and enforceable tenancy agreement. The defendant occupied the premises, paid rent for part of the term, and acknowledged the relationship. The plaintiff was entitled to recover arrears for the period the defendant was in occupation without payment. The defendant's claim for set-off of legal fees was only partially substantiated as only certain amounts had been taxed and credited. The plaintiff's claim was overstated regarding service charge and interest, and the court recalculated the sums due, allowing only proven arrears and service charge, and awarding interest at 14% per annum from 1st May 2013. The defendant's broader set-off claim was rejected as it was not fully pleaded or proved. The plaintiff, as a successor to City Finance Bank, was entitled to judgment for recalculated sum, interest, and cost. So, inasmuch as the formal lease was inadmissible, the conduct actually fell in compliance with Section 58 of the Land Act. A periodic lease is a short-term lease and is not a registrable interest. It may be oral or written. So we have answered the question. Explain the legal effect, explain the advice and the safeguards that you ought to have taken note of. So the question wanted 3 marks. Okay. Question 6. Nadhani sikujibu. Question 6. You have just been admitted to the role of advocates. Fortunately, the government has employed you as a registrar of titles. Pendo approaches you informing you that his land parcel number 2009 has a fake copy of title in circulation. Pendo is scared that the title may be used to defraud unsuspecting persons, and it could also be used to effect a transfer of title. What action should you as a registrar take to protect or prevent the fraudulent transaction? 1 mark. 2. Explain the legal procedure you will follow in protecting or preventing the fraudulent transaction. C. Another client, Huruma, claims to have bought the same parcel from Pendo. Huruma has proof of having paid the 20% deposit. However, Pendo has been approached by Kweli to sell to him at a higher price. Explain to Huruma the action he can take against Pendo. D. Explain to Huruma in detail the procedure to be followed in the action selected to in C above and the necessary documents. So basically, we can say that CLE usually tests a mastery of a certain principle, and in a test in various facets, or to see whether this student amekram ama anaelewa what is actually happening. So in this case, you have been appointed as a registrar of title. A inasema that take an action to protect or prevent any fraudulent transaction, then explain the procedure, hiyo ni 4 marks. Then before you go to C and D, kwanza tujibu hizo. Registrar's immediate action, 1 mark. Enter a restriction against LR 209-1 to prohibit or restrict dealings pending inquiry or anti-fraud hold. Section 76 of the Land Registration Act. What is the legal procedure to protect or prevent the fraudulent transaction? Open an inquiry, issue notices, hear affected parties, then register a restriction. Once registered, no inconsistent instrument can be registered unless lifted by the registrar or court. I believe now sasa background noise imeongezeka, but luckily we are in the final question, then I end the session. So, registrar may, to prevent fraud or improper dealing, after inquiries and notices plus hearing, make and register a restriction prohibiting or restricting dealings. So I beg you to follow through from what is being projected in the screen because of the noise. So registrar must give written notice of restriction. Inconsistent instruments cannot be registered while the restriction subsists except by order of the court or registrar. Judicial interpretation. Restrictions must be justified and are challengeable. Registrar can lift them where unsupported. Okay? Practical steps. What you actually do at the registry. Receive the complaint, verify proprietor, okay? Registry inquiry, issue notices, register restriction, then operational control, circulate internal alert on the parcel. Then C, Huruma's action against Pendo, sue for specific performance. So I greatly apologize for the noise, but naweza sema that I want you to duly follow the screen so that you take notes here hizo answers. But we can, nikischedule next session, tutaanza na hii question, the last question that I'm working on, so that tukue tumecapture the content vizuri. So don't worry, we will revisit the same. We will revisit this question. I greatly appreciate. Allow me to end the recording while I see anything. Thank you all while we will resume from question number 5. Thanks. Thank you, Chebik, and thank you, Mr. Muraro. Thanks. Let me end the recording, alafu tuta resume.